I want to ask you about another thing, though, and this is kind of a pet issue of mine because I wrote about it in AR2 Handbook for the Second American Revolution. In that book, I propose a plan to reestablish the Constitution. Basically, we're saying that the Constitution is moribund. You know, it has been redefined to such an extent that it really doesn't even exist to the point. Our job now is not to preserve, protect, and defend. Our job is to resurrect the Constitution. And I felt that the first step in doing that is to acknowledge that the Constitution is not our founding document. The Declaration of Independence is. And it's important that we start there because in the Declaration of Independence is a very simple, a very elegant, and very eloquent statement of what our government is here to do. And it's found in the most memorized portion of the Declaration of Independence, but it's perhaps clearest if we take those passages and read them in reverse order. When we do, here's what we get. Governments are instituted among men to secure these rights that are endowed by their Creator. That is our basic philosophy of government. It's not everybody's philosophy of government. Some say that the governments are instituted among men in order to secure the rights of the oligarchy, or of the monarchy, or of the Politburo, or something like that. But that's not us. That's not the United States. Here we said that governments are instituted among men to secure these rights, the holy trinity of which were life, property, liberty, and as you pointed out, the ability to secure those basic rights. Now, it's important that we start there because my argument is that the Constitution was written in order to implement and institutionalize the philosophy of government that's in the Declaration of Independence. So that whenever there is some confusion about whether a law is constitutional or not, whenever there is some lack of clarity about what the Constitution really says, we need to go back to the basic document. We need to go back to the Declaration and those magic words there that provide us with the clarity. I call this concept linkage because we must link the Constitution to the Declaration. Basically, the Declaration provides the lenses through which the Constitution must be read. If we take our glasses off, things get fuzzy, we make mistakes. Now, using that principle of linkage, we can look at certain key issues and make a determination about whether the court was in error in the past and past decisions. For example, Roe v. Wade, January of 1973. The court said that women have a right to privacy which allows them to kill their preborn children. Where is that? Well, if you look at the Constitution and read it through the lens of the Declaration, we find that that's not so. Because it says that we hold these truths to be self-evident that all men are created equal. You are created equal on a legal basis. Your legal rights are the same from the moment you were created. You do not grow into this right. You do not evolve into this right. You do not have to earn this right. You do not have to pass any test to get this right. From the moment you are created. And the moment of creation is the moment of conception. And whether you get into all of these squirrely arguments about when does life begin, when does personhood begin, there's no question about when you begin, and that is the moment of creation. That is when you are created. That is the moment of conception. Now, with linkage, we can prove there is no right to abortion. Same-sex marriage, same thing. It says that rights came from God. Well, if rights came from God, rights are basically something that God gives us permission to do. Well, He is not going to give us permission to do something which He regards to be abhorrent, detestable, or an abomination. Same thing with all of these transfer payments that are taking place in order to fund a whole range of entitlement programs. That's a violation of our property rights. So over and over and over again, we see this. And linkage is basically, I call it the bullet. This is the bullet that can get the job done. But we need a rifle to fire the bullet. And that, I believe, is what we've talked about before, the concept of the constitutional sheriff. Now, the concept of the constitutional sheriff holds that a sheriff took an oath to preserve, protect, and defend the Constitution of the United States. Not to keep his uniform pressed and his shoes shined, not to keep the local politicians happy or out of jail, not even to keep his people safe and to enforce the other laws. That's part of it, but his ultimate responsibility is to preserve, protect, and defend the Constitution. That being the case, a sheriff, as the chief law enforcement officer in a county, could say, you know what? There will be no more abortions in my county because it is clearly a violation of the right to life. You know what? There will be no more same-sex marriage licenses issued because it's clearly not the will of God. You know what? There'll be no more of this collection of taxes at the county level for redistribution of income because it is clearly a violation of your property rights. Now, in AR2, I took this concept and expanded it from the idea of the constitutional sheriff and applied it to a governor, that a governor could do the same thing on the state level. So, what are your thoughts about linkage and applying this concept of the constitutional sheriff to a constitutional governor who could use linkage to accomplish amazing results in a very short period of time?
I would say anybody who raises their hand and takes the oath to support and defend the Constitution of the United States bears that duty and responsibility to refuse to comply with anything that does not comply with the Constitution. And the 10th Amendment makes it very clear that the powers that are not delegated to the federal government, and I mean specifically enumerated, are reserved to the states, which means that you cannot violate, the federal government cannot violate that principle of, if it's not been delegated to you, you can't exercise it. Life has not been delegated. Here's the problem, though. Again, back to Sam Adams. When the people become universally ignorant, and that's what's happened here, the people have become universally ignorant because marriage, period, is not a federal issue. Marriage, period, is not a government issue, if you want to get real technical about it. Because if you believe that marriage is a union between a man, a woman, and God, then where does government fit in that trinity? Nowhere. And the real problem here is that even Christian conservatives are asking the government, the federal government especially, to do things that the federal government is not delegated to do. We went, as a Christian whole, conservatives as a whole, went to government first and asked for the government to define marriage through the Defense of Marriage Act. The Defense of Marriage Act is completely and totally unconstitutional because marriage was not delegated to the federal government. At best, it's a power reserved to the state. And as an evangelical, you should not believe that government is involved in marriage, period. We should have pastors refusing to issue marriage licenses, saying, look, I will marry you under the eyes of God before this church. But if you want government approval for this marriage, then go find some government agent to marry you. I will marry you before God. And that's how we keep government out of our church, but we keep inviting them back in. The conservative Christians asked the federal government to define marriage, and they did. But every time we ask the lion out of its cage, we shouldn't be shocked and amazed when it tries to bite our head off.